who exactly issues that majority opinion, who authored that will be interesting, and also the breakdown of the justices. Will this be unanimous? Will this not be will this be a split vote? It will be very interesting to see exactly how all of this is handed down. This really has centered around a phrase, which is and if you would explain all of that when it comes to official acts. And that really seems where all of those arguments, when we were listening to the arguments here live on LiveNOW from Fox, what constitutes an official act? Can you explain the significance of that phrase?
Well, you would think that what constitutes an official act is something that would be relatively straightforward to define, but lately it feels like that's been asking the question of how many angels can dance on the head of a pin. And what constitutes an official act is something that we're going to get a refined answer to in the next minute or two. So that, again, is one of the interesting aspects of kind of running this on the fly. But generally speaking, something that occurs as an official act is an action that is implemented or taken by the President of the United States in furtherance of his official duties under the Constitution, versus a personal or a political act, which is not done in furtherance of the office, but done in furtherance of the person, the individual. Is it done in furtherance of the office and for the people of the United States of America, or is it a personal political act for the individual? And that really is the lens that's going to rise out of this opinion. That'll be literally coming and physically be coming into my office any minute now. So that really is the standard. And I really do say that this is akin to certain kinds of cases, like employment cases. There are many instances and times in the law where there's a question of whether someone acted within or outside of the scope of their authority. Of course, this is one of monumental constitutional significance. But one of the things that I found interesting about this chapter of our judicial history is that it really shouldn't be that complicated. And in fact,
actually, Seth, can I just interrupt you right now, because we
Sure.
have just received word that the Supreme Court has handed down that ruling. I was just given a copy, and I'm sure your colleague is going to hand you a copy right now. Again, we can read it together. This is raw and unfiltered. But
Yep.
what I do want to share, and I'll just read a first few words for you, and sentences rather. A federal grand jury indicted former President Donald J. Trump on 4 counts of conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that any former presidents do not possess federal criminal immunity for any acts. The D.C. Circuit affirmed. Both the district court and the D.C. Circuit declined to decide whether the indicted conduct involved following acts. We're continuing to read it here. There is no immunity for unofficial acts. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all his official acts. And again, it continues. But again, that was just the first portion of this ruling. Seth, as we continue to comb through this is raw, this is unfiltered, hot off the presses, as you mentioned. What do you make of that?
Well, and my hot off the presses copy will probably be here in about 90 seconds because my colleague down the hallway is printing it as we speak. But so far, that makes sense. So what the Supreme Court is opening by saying is they're kind of setting the table, if you will. They're saying that if there is an activity that occurred within the scope of the president's official duties, then he or she is entitled to executive immunity. That aspect is not surprising. But keep in mind, as we continue to digest this, and it'll probably take a few minutes to do that, that's really just the tip of the iceberg, because as what happens in these cases is there's rarely a clear evidentiary line. That's a logical place to start. If the Supreme Court says that if there are things that happen within the ambit or even within the outer reaches of an official duty, which is really just a fancy way of saying that it's within the official duty, then there is executive immunity that applies to that. So in terms of what we're reading on it so far, that makes sense. But again, as we continue to digest, the devil will be in the details there.
And part of this also says this case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We were talking about the historic nature of this. Can you explain more? Obviously, the justices also felt that weight of this historic moment. But can you talk more about just how landmark of a case this is and this decision?
Although this is not the first time that the Supreme Court has weighed in heavily on a matter of very clear, weighty significance in the history of presidential elections, see, for example, Bush v. Gore, this is the first time, as the Supreme Court is noting there, that we are looking at alleged criminal activities that took place prior to a president of the United States leaving office. He has been subject to indictment, frankly, more than one. But as far as at least the D.C. election subversion case is concerned, this is a first in history.